She sued her own brother after 11 years of building his empire. She didn't just sue her employer after a slip and fall, she sued her own brother, and the courtroom hadn't seen anything like it since. The plaintiff had worked at her brother's landscaping company for 11 years. She was his first hire, his most reliable crew supervisor, and by most accounts, the backbone of a business he'd built from a single truck and a dream. The defendant, her younger brother, had grown that dream into a 14-employee operation generating roughly $800,000 in annual revenue. By all appearances, it was a family success story. Until a Tuesday morning in March when everything fell apart, quite literally, on a wet concrete walkway outside the company's storage warehouse. The plaintiff slipped. She fell hard. The emergency room confirmed a fractured left wrist, 2 herniated discs in her lumbar spine, and nerve damage that her orthopedic surgeon testified would affect her grip strength permanently. She was 43 years old and had spent her entire adult life doing physical labor. The injury wasn't just painful, it was, she argued, career-ending. She filed suit against her brother's company for $387,500, covering medical expenses, lost wages, diminished earning capacity, and pain and suffering. In court, the plaintiff's attorney painted a damning picture. The walkway where she fell had been flagged in an internal safety inspection 6 weeks before the accident. A handwritten note from a former employee identified the concrete as cracked and drainage compromised, a hazard that worsened dramatically in rain. On the morning of her fall, it had been raining since before dawn. The plaintiff testified through tears that she had mentioned the walkway to her brother personally, twice, in the months prior. She wasn't just an injured worker. She was a loyal sister who had trusted him with her livelihood and her safety, and he had let her down. The defendant's case was quieter but firm. His attorney acknowledged the injury and expressed genuine sympathy, but argued that the plaintiff had been aware of the conditions, had worked that site daily, and had chosen to cross that specific walkway rather than use the covered side entrance just 20 feet away. More critically, the defense presented the company's maintenance logs, which showed a repair order for the walkway had been submitted and approved before the accident. A repair that had been delayed not by negligence, but by a scheduling dispute with the contracted paving company. He wasn't ignoring the problem, the defense argued. He was in the process of fixing it. Reasonable timelines, not reckless indifference. The courtroom was split. The siblings had not spoken since the lawsuit was filed. Their mother sat in the gallery on the first day and did not return. Then, 4 days into testimony, the twist arrived in a manila envelope. The plaintiff's former office manager, who had left the company 8 months before the accident, had kept a personal copy of a document she was never supposed to have. A signed liability waiver. Not a general employment waiver, but a specific one, drafted when the plaintiff had taken on the role of site safety supervisor 2 years prior. In exchange for a $4,200 annual stipend added to her salary, she had acknowledged in writing that she accepted responsibility for identifying and reporting unresolved hazards at all company-operated locations, and had waived her right to personal injury claims arising from conditions she had personally documented as known hazards. The walkway was on her own inspection list, in her own handwriting, dated 5 weeks before her fall. The document had been thought lost in a server migration. It wasn't lost, it had simply been misplaced in a folder mislabeled during the transition. And the former office manager, watching the case unfold on a local community news blog, had quietly retrieved it from her personal archives and contacted the defense. The judge reviewed the waiver carefully over a recess that lasted almost 2 hours. Her ruling was measured. She found the waiver legally valid and enforceable as it pertained to the general negligence claim, which she dismissed. However, she drew a sharp line at the medical expenses. No employment contract or liability waiver, she ruled, could compel a worker to absorb the direct cost of a physical injury caused even in part by a known, unrepaired structural defect on company property. She awarded the plaintiff $94,000, her documented medical costs and physical therapy expenses, nothing more. Neither side celebrated. The defendant paid the judgment within 60 days. The plaintiff used a portion of it to retrain as a bookkeeper. They have not spoken since. Their mother reportedly still sets 2 extra plates at holiday dinners, just in case. The waiver was real, the hazard was real, the injury was real. The neglect, his or hers, is still being debated by everyone who knew them, which raises the question this case never fully answered. When you sign away your right to be protected, does the person who let the danger exist still carry any moral responsibility, even if the law says they don't?